Good day to you, wherever in the world you may be watching or listening to this. My name is Gordon Harris from the Gowling WRG International IP Leadership Team, and this is the latest in our series of interviews with leading figures in the IP world. The IP world is full of organisations with initials for names, which host meetings and conferences for lawyers, patent attorneys, counsel, etc. However, I think it is fair to say the really important people in our IP world are those who create, register and own IP rights. In the UK, the big IP owners have their own organisation, the IP Federation. And my guest today is the current president of the IP Federation, Scott Roberts. In his day job, Scott is principal patent attorney at British Telecom, and he sits on numerous committees and advisory boards. If I listed them all, it would take up all our time. So welcome, Scott.
Thank you, Gordon.
Let's start with learning a bit about how you got to your current, well, many positions in the IP world. Where did it all begin for you and how did you get into IP?
Oh, that's interesting, because sadly, it started with not the least bit interest in IP. So as a kid, I was a computer programmer. I was a computer programmer from about the age of 10, always programming games. I remember well, my brother would be my bug finder, and we would sit there together in the bedroom. I'd be programming away and he'd be, I'd spend 6 hours programming, he'd spend 10 minutes and find all the flaws. So that was my passion as a sort of teenager, and at the age of 16, I produced a vehicle navigation system in software. So that was before GPS and sat nav. So, that was kind of fun. And we didn't have, vehicle tracking or monitoring technology back then. So I then had to move on and produce a simulation for traffic. So I did all that sort of stuff at school and I absolutely loved it. And I was really lucky to then be awarded a scholarship to study computer science on IBM's dime, which was quite rare. I think they would sponsor about 15 students a year. So it was quite competitive and I had to really prove myself, but I was so passionate about programming and I'd done it for so long that that was just my thing. It was my bag. Thoroughly enjoyed that. So I spent the 3 years of my degree working at IBM whilst taking a sort of day release approach to university and getting a degree through that route. I'm not sure I'd have gone to university if it hadn't have been for IBM, in fact. I wasn't from the wealthiest of backgrounds, so uni wasn't necessarily on the cards. So I was really, really pleased and grateful to have had that opportunity. And it naturally led to a role at IBM as a software engineer, which I did for about 12 years, I suppose, after that. And I worked mainly at the software development lab in Winchester at IBM. We were writing the Java virtual machine for any software people out there who know about Java. We weren't writing in Java, we were actually writing Java, which was fantastic. And none of my friends would believe me. They'd all think, oh, you mean you're a Java programmer? And say, no, we're writing Java. It was phenomenal. But after 10 years, it did occur to me that writing software for someone else is not as much fun as writing it for yourself. It's not the same as being in your bedroom writing computer games. So I did, I suppose it became a little stale for me, and I did look around a little, and that was the point when Roger Burt, actually, who's a fairly well-known patent attorney, now retired in the profession, who's the IBM head of department, took me under his wing and trained me to be a patent attorney in IBM. And I worked with Roger for 10 years, all of the patent lawyers at IBM, and directly with Dave Kapos, who was the head of the IP function at IBM for a good long while there, before, of course, he went on to be the head of the USPTO.
Well, quite, yeah.
It was a really incredible experience, actually, because not only was I looking after what you normally do in-house, sort of IBM legal issues and intellectual property protection, but Dave was, maybe a precursor to his role at the USPTO, was very in and involved in policy issues. And we were looking together at international patent harmonization. I produced a paper for Dave to share on collaborative examination by patent offices around the world, so bringing together the key patent offices, sharing work products, sharing search reports, collaboration between the examiners on examination reports. And that really sort of positioned me for both sort of a hybrid job in being a patent attorney, doing the core job, and working on policy issues. And in fact, it was at that time that I moved house. And as you often do when you move house, you go through all of your belongings from years back. And I went into the loft and I dragged out all my old books and what have you. And I found a printout from my school's career service. And at the very top, so this was a printout. You would fill in an online questionnaire, and this very special computer, a bit like Ernie, would come out with a list of jobs that would be well suited to you. And I was always pleased as a kid that number 2 on the list was computer programmer, because that's all I wanted to do. And it wasn't until 20 years later when I went into my loft and got this printout and sort of spotted number 1 on the list was patent attorney.
Wow.
Because as a kid, I had no idea what that meant, and frankly wasn't at all interested. But 20 years later, to find that I had fallen in to the job that Ernie thought was my top job was quite remarkable. So I was really kind of chuffed. I thought that was quite telling. It really does work, everybody. Those
yeah, well, I did exactly the same test, and it told me I'd be a lawyer. So here I am.
There you go. You see, I mean, it's sad if you get answers you don't want, but for me, it worked. So yes,
something in it.
I left IBM after about 20 years, spent some time in private practice. It was a very insightful experience. Then I went to work for BT, and I've been at BT ever since. I've loved BT. It's really great to work in British industry. I especially enjoy the fact that, of course, being British industry, the buck stops here in the UK. And that's really empowering, because when it comes to policy, strategy, commercial nous, then being at the place where the final decision rests here in London and the UK is very, very powerful and encouraging. So I've been doing that now for about 10 years, and I absolutely love it. Very much a fully laden patent attorney. I'm not one of those in-house attorneys that sends all of our work out to outside lawyers. I do a very healthy number of drafts every year, very healthy amount of prosecution, still attending hearings, still advising directly with inventors, and loving every minute of it. So yeah, that's how I got to where I am. And of course, president of the IP Federation came after that. I've been working with the IP Fed for about 10 years now, and I was appointed president in 2020, which is just an absolute privilege.
Well, we'll come back to a bit. There are some fantastic clues there as to what happens later in your career, which we will come back to later. And the only thing is, I just don't know how you fit everything into your day, judging from what you've just said there, but there we are. So your focus really, as you said, pretty much since a child, have been on IT tech related matters. And over the last 25 years or so, the IT world has progressed at such a phenomenal pace. And if anything, that now seems to be accelerating. So, how have you gone about keeping up with the pace of change in your working life?
Well, my first observation would be my wife would very much agree with you, wondering how I fit it all in, and she has a point of view on that too. Keeping up with technology and the pace of change, it's a huge challenge. I mean, it's true for all patent attorneys. And I speak from the profession I'm in, patent attorney profession, but I'm sure it's the same for all IP lawyers and that ilk. Because the technology we're working with, we're not at the front of the technology, we're not sort of the leading edge, we're ahead of the leading edge. I always think of it as a sort of the front line in an ever-increasing sphere. And we're always outside it, trying to stay ahead, because the inventions and the tech we work on, of course, it's all new. It's all completely unheard of by its very nature. So we're always jumped over the front line and looking back at it. And that's incredibly difficult to do. Even the scientists and engineers who work as scientists and engineers struggle to keep up with what their peers are doing all the time. And as patent attorneys, of course, we're having to do the same thing without the benefit of being the scientists and engineers who are paid all day to work on this stuff, other than when we're talking to inventors. So that is a huge challenge. And I would come back to the fact that at my core, I'm a scientist, and I always have been, and never stop being, and never will stop being. And to talk about computer science, I miss programming every day. I actually, I can come home at the end of the day and just wish it was a reasonable thing for me to spend 7 or 8 hours at my PC tapping away in C. It's not a reasonable thing, because I've got plenty of other things to do, and my wife would hate me for it. But I would genuinely not want to do anything else if I could. But that sort of passion makes it easier for me to try and keep up. I'm not saying I stay ahead, but to try and keep up, because I'm interested. I'll read the journals, I'll read the books, I listen to the inventors. And I do think if there's one thing, if I could affect sort of education policy in the UK, I really do believe that it would be beneficial for everybody to have programmed a computer at least once. I mean, it's essentially just mathematics, but the way that programming forces us to analyze problems extremely logically, and the way that the machines we program, they're not very clever really. And so you have to piecemeal give them every instruction and then contemplate every state in which they can exist. That approach to looking at problems and that approach to looking at technology, which we can always resolve to first principles, can be applied to other aspects of our lives. And I do this with inventors. When I work with inventors, I very much like them to program me with their invention. So start with me being a blank state machine, and then just give me the insight I need, and only the insight I need. Don't tell me the stuff I don't need to know about, because it's just going to fill my RAM. But give me the insight I need, and I will, by piecemeal, hopefully understand the instructions you're giving me, and in theory, understand your invention. And the good thing about things like programming and mathematics is it doesn't change. So although the leading edge of technology is always moving on, the fundamentals are always the same, first principles. One technique that I've really enjoyed using and has been very powerful for me in working with inventors, for example, in high tech, is to always reflect inventions back to the inventor, impromptu, in my own words, in a very, very short sort of précis form. And I had a meeting recently with an inventor, so a PhD student working with BT that had been working on some tech for about 2.5 years. And she presented the tech to me over about an hour, and it was complicated stuff. And I'm always thinking claim language. It's almost like programming is a bit like claim language, pattern claim language. And so I was constantly taking in what she said and, rejigging it, generalizing it, broadening it, being more reasonable in terms of scope. And we got to the end of the hour, and I went back to her with a sort of 5-line précis of what I thought the invention was. And she was a bit disappointed because her 2.5 years of work had been resolved to 5 lines. And, it's always good if the inventor can't fault those 5 lines. But, it's rarely the case that they can't fault them. But if you can get 5 lines or 6 lines or a paragraph that reflects the hour-long conversation, then I think you've done the job well. And first principles, it works, I think.
That's really interesting in many ways. I mean, I want to move on to IPFed in a minute, but you've handed me such a teed one up there. You said that the machines you work with aren't particularly clever. Yeah. So I can't not ask you now about artificial intelligence and whether that is impacting on you yet, and any thoughts you have in that area.
Absolutely, yes. So I'm very passionate about artificial intelligence, and I prepared a couple of consultation responses to the recent UK consultation by the IPO on AI and IP. In terms of technical, so I think your question is about the technical potential of AI.
It is.
We don't have artificial general intelligence at the moment. Sci-fi is not real, and it's not foreseeable. It's also not foreseeable. And let's remember, I mean, we need to stay grounded, I think. Artificial intelligence is a tool. It finds its origins in how we can program computers to do things where to tell them how to respond in every situation is unreasonable and impractical. So an example would be speech synthesis or handwriting recognition. I cannot reasonably sit down and program a computer to recognize every single handwritten letter A. It's just not possible because the number of variations is phenomenal. And you'll know, as a human, there are many letter A's that don't look like letter A's at all. So how can I even start to tell a computer to distinguish an A from an O or a B or something else? So the inspiration for machine learning as we have it today is that there are problems that exist that we can't program a computer to solve. And AI and machine learning is the way to do that. It's to say, well, we can't tell you, computer, how to do this, but what we can do is show you a whole lot of examples, and you will just pick out the salient points, computer. And when you've picked out the salient points, please apply that to another one I'll give you and see if you get the right answer. So, that in a nutshell is AI. It's very much a tool. It's a new way of programming. If I was to talk about questions that have been raised, like can AI invent, I think the answer is fairly clear. AI can create novelties. AI can help us discover new and clever things. But AI is a machine. It's a tool. It's part of the armoury of the inventor, I think. So yeah, we have to be careful to stay grounded with that dialogue, I think.
Yeah, I mean, I think that's a really important point, actually. At the moment, I had one of these conversations a few months ago, you may have seen, with Ulrika Till from the World Intellectual Property Organization, who's head of their AI policy. And we got round to discussing whether or not AI could write the perfect Eurovision Song Contest entry, which I said was the ultimate expression of rubbish in, rubbish out. And that is still very much there, isn't it? It's still, AI is only as good as what we put into it at the moment.
And there's always that problem of what is perfect. I mean, one of the challenges with AI is it needs to be guided. It needs to have an objective, and somebody has to set that objective. There are those who contemplate the possibility of AI being very generalized and sort of serendipitously discovering novelties, and that is possible. I could send a machine off to go and discover things, but at some point someone has to determine that a novelty is useful, is applicable, is even a novelty. Those sorts of questions that have to accompany whatever serendipitous discovery takes place means that there's likely to need to be a bit of wet brain involved as well as the silicon brain.
Yeah, I think that's good to hear. Frankly, I think we're all a bit relieved by that. So let's move on to IP Federation. So the organization celebrated its centenary in 2020. How would you describe its work and its role representing IP owners in the UK?
Well, the IP Federation is, I mean, it's a phenomenal association. I'm really privileged to have been elected the president for this year. So just as a basic background, we're 45 member companies at the moment. And what's really special about us is that we are not sectoral. Most associations are either industry sector or profession. I mean, with the exception of national, like the CBI, most associations are specific to one profession or an industry. But we are completely cross-sector, and we are focused on the core issue of intellectual property. We've got members from my field, IT and telecoms, and we've got members from fields that are completely different in their approach to IP, such as pharma. I mean, a pharma IP strategy is very different to a telecoms IP strategy, but they work together very well through the federation. We've got manufacturing members, aerospace, automotive, agri-science, they're all there, even consumer and retail. And the point of the IP Federation, its reason for existence, is to advocate for the right IP framework for industry, because industry recognizes that it holds the checkbook ultimately when it comes to the IP framework. We tend to pay the bills on registered rights. We pay the cost if there's an infringement. We enjoy the benefit as well for rights that we own and can commercialize. But so it's a sort of two-sided sword, and we very much recognize that there needs to be a voice for that sector of the IP stakeholder framework, that the owners or the applicants. As a federation, we're organized as a council, and I think we're quite rare. I'm not aware of any other association that meets to discuss technical issues in its field on a monthly basis, and we do that. And these monthly meetings, as I say, they're not administrative meetings where we talk about admin and business. We're talking about actual IP issues, and we're formulating policy, and we are exploring how we're going to influence stakeholders and policymakers. And we do that every month, first week of the month, and it works very well. It takes all morning. And the people in that room, member representatives, are generally lawyers, patent attorneys, trademark attorneys, solicitors, barristers from the member companies. So they have the technical insight in addition to the commercial insight into their industry. And we also enjoy the benefit of very selective representation from some of the law practices. We have some associate solicitors and barristers, and we also have former members who have great experience, maybe retirees of the member companies, who work with us as policy advisors, and we employ consultants as well where we need to. And we've grown a great reputation. I think we stand up as probably one of a few pillars in the IP framework in the UK, certainly when talking to government and, for example, the European Patent Office, that sort of organisation. And we're depended upon by the CBI, Confederation of British Industry, for IP expertise, because CBI covers everything, and IP it's a very specific technical area. So there is an element of dependence on us for that, and through the CBI we have representatives directly on Business Europe working groups. Business Europe being the sort of European CBI. It's like the confederation of all the confederations. So not only are we helping with the UK Industry Confederation, but also the European. And by European, I'm not talking EU. Business Europe is true Europe, geographic Europe. And through that, we then represent industry at the European Patent Office, for example, through the Standing Advisory Committee, SACIPO. And also one of our representatives is representing Europe in the industry trilateral on patent harmonization. So the industry trilateral is the bringing together of industry in Japan, the US and Europe. And it's ultimately an IP Federation policy advisor through the CBI, through Business Europe, that represents European industry in those discussions. And that is fantastic for us. It works two ways. We get that feedback from the meetings from the horse's mouth, and we can help enter into that dialogue, insights, evidence, and information. So, yeah, in terms of the value of this federation, it's always been clear to me, and it just continues to go from strength to strength. I'm very proud to be part of it.
So you condense then the primary goals. What is a successful outcome on a particular issue if you get involved? I mean, obviously, the last year or so, you've been very heavily involved in all the lobbying around the impact of Brexit on IP in the UK. Where's your starting point when you approach an issue like that?
I think evidence. It's clear to us that to have any impact at all, one needs evidence of the impact, or evidence of the potential proposal, whatever the proposal happens to be. And the IP Federation has learned over its 100 years that evidence is king, in a sense, and it has to be credible and it has to be real, and you can't fake evidence. It's either real or it's not. So our perspective has been that where a problem, an issue, a challenge, or a policy situation arises that we want to have a stake in and enter into the dialogue for, we need to start from a point of view that says we don't just explain what we think is right because it benefits us personally and directly. We want to see what's right from an entire cross-sectoral perspective, because of course we can't, we're not just here to advocate for pharma or telecoms, we're here to advocate for all of industry. So first of all, we have to recognize that the benefit of whatever position it is we're condoning is across all of our sectors, because we do often operate on the basis of consensus, frankly. And then secondly, we need to be able to demonstrate that that's the case. So examples recently, you mentioned Brexit, and Brexit's not Brexit per se is not a huge intellectual property issue for our members. I mean, there are specific issues. We had the issue of access to the EU IPO, for example, which is clearly affected by Brexit. But on the whole, if you take patents and the fact that the UK government has been able to make porting of rights into UK law, there's a tempering of the impact. But it's what comes next where we have seen some challenges, and in particular trade discussions. I mean, the phenomenal opportunity to enter trade deals internationally comes with an additional challenge, which is that trade deals usually include intellectual property provisions. And so we have an interest in making sure we understand those, and we help the stakeholders, so the governments, understand what is and is not maybe appropriate to do in those trade deals. And evidence is always key for that. One of the most important, it's important to have evidence, but it's also the most challenging thing to do, because getting financial numbers, for example, together from a suite of 45 companies who, it's proprietary information. So you're trying to get a suite of companies to give you evidence, and then you can't really share it. So that's always a challenge as well. So we collaborate with other stakeholders. So we've worked with SEPA this year in preparing an impact assessment on one particular issue in relation to trade deals. We employed the services of Tony Clayton, who is a former chief economist at the IPO, to do some work for us and SEPA, bringing together publicly available information to build a compelling case so that government could see a particular policy position we take, the sense behind it, and hopefully take on board all of that information to make, to sort of start moving the liner in a slightly different direction. It's like turning an oil tanker sometimes, but it's what we do. It's our day job in the IP Federation.
Well, I'm aware of certainly some of the effectively lobbying that's gone on this year, and the evidence-based approach, and it certainly appears to have worked in a number of cases. So, we're living in a time of change. What do you say is the biggest challenge facing UK-based IP owners right now? You've indicated that Brexit may not be that much of a challenge. COVID doesn't appear to have adversely affected IP particularly. It's still, rights are still being registered, and patents, trademarks, the like. What are the biggest challenges, do you think, facing the IP world now?
Well, I think there are two. I think I've thought about this for some time, because it surprised many that Brexit wasn't, I mean, Brexit has its impacts, as I mentioned, but it surprised many that Brexit wasn't a phenomenal challenge. COVID was an interesting one, because although, you know, IP and COVID, they might not overlap, it seems, but the thing with COVID is that many businesses that are and have been fundamental to addressing the COVID challenge this year are businesses that are rich in innovation and rich in intellectual property. And there's always been a sense in the public dialogue and in public discourse, a sense of uncertainty about how IP plays in the case of a crisis. And, you know, I've been very clear that, you know, some business models just don't work if you can't protect your intellectual property. And I take pharma as a perfect example. You know, investing that much time, effort and money in producing pharmaceuticals even outside of a crisis is not something that anybody would find worthwhile to do if they weren't able to actually enjoy ownership of the resulting product. So where we are today is a product of that system, of that intellectual property system. The very fact that we have pharma companies able to, with the resources they have, to engage in new innovations in testing, new innovations in vaccination, you know, that is a product of the IP system. But in terms of, so COVID, yes, has been a challenge because of the public perception to some extent, and we've hopefully helped with that to some extent. But I think there are definitely two main issues at the moment. The first is trade, as I just mentioned, and it comes as a surprise to most, but I do think that this potential unsettling of IP provisions domestically because of pressures arising from bilateral trade discussions is a challenge. And as I've said, we're very much on board with that. The second, and you've alluded to it already, is technological advance. The fourth industrial revolution, as we like to call it in computer science and whatnot, it is bound to have an impact on how one sees intellectual property, how intellectual property owners protect, recognize, and advocate for their property. So we're talking about artificial intelligence, which we've discussed, Internet of Things devices, what we call, you'd call it blockchain, distributed transactional databases, I like to call them. These technologies, they generate a lot of data. They generate a lot of new insights. You have tech that is doing stuff it's never done before, you know, learning for itself. And the IP system is being tested at its edges, on the fringes here. Data is a really good example, actually, because you have IoT, Internet of Things devices spread all over the place, generating phenomenal volumes of data, which, you know, individual items of data may seem worthless, but when you put all this data together and you have a mass, you can have some phenomenal volume at real value. It can be used to train AI neural networks. It can be used to mine for new insights. And there are real challenges. Who owns this data? Who has the right to use this data? How can this data be applied? If the data is applied, who owns the valuable products of its application? So who owns the trained AI that was trained based on massive volumes of data? These are challenges, these are questions. I don't have the answers for these just now, but that's the sort of threat, that along with trade, I think are the sort of threats to the balance of the IP system that we're seeing at the moment. And, you know, which, as I said earlier, we have to keep remaining grounded and look at it, I think, from first principles. I think that approach of going back to first principles all the time is the helpful approach for these issues.
I think taking a step back and looking at things is definitely, you know, taking a helicopter view is definitely worth doing. I mean, there's always a risk that as technology evolves, the IP world finds solutions in like little micro new sui generis rights, whether it's to protect data or aspects of tech. But you know, it must warm your heart as someone who's worked in the tech world all their life to see that now everything is emerging around tech. So we have fintech, financial services technology, we have meditech, wearable technology, we have real estate tech, you know, everything is sort of coming together. And I do feel, I had this discussion with Ulrika from WIPO, we may need to step back and take a new look at the landscape and say, well, we might need to redesign some of our rights a little bit in order to cater for this new world. Do you agree with that?
I do. And what's really telling, an area of economics that I've taken a personal interest in is the balance between tangible versus intangible investment. And I don't know if you follow this, I do. It's a sort of sad sideline of mine. But around between 2012 2015, I believe, there was a switch. the investment by business in the UK switched from being substantially majority tangible, so equipment, machines, vehicles, that sort of stuff, to intangible. So essentially the stuff that is protected by intellectual property and trade secrets. And that switch took place around the middle of the sort of between 2010, 2020. And that was a real shift. And when you look at the individual sectors, you can see that the sectors that is really true for increasingly are financial services, are medtech. Those are the sectors which, okay, you might think, well, yeah, naturally those sectors are dependent upon intangibles. But then you've got other sectors where this is also growing. Manufacturing sector has an increasing investment in intangibles. Now, again, technology innovations, it would be common sense. But the fact that the overall number is now, or was balanced towards intangibles, was fascinating insight. And another thing I'd mention, I mean, it's switched back a bit now, and I don't know if that's because of the effects of maybe Brexit or COVID, certainly COVID, but we now have more tangible investment than intangible. But it's definitely that the lines are playing with each other, toying with each other. And it really emphasizes that high tech and its application to various sectors in new ways, like drug discovery, AI application to drug discovery. It does warm my heart, and I do find it encouraging. And I do think that therefore we've got to keep our IP system relevant for that. So whether it's sui generis rights or whether it's just acknowledging the first principles of the existing rights or a combination of both, and making small adaptations where necessary. But we need to be on top of it, definitely.
Now, let me swing round and change tack a little bit. Right at the very beginning in your opening comments, you dropped a little hint about my next question. Because I know that diversity and social mobility are topics that are very close to your heart, and indeed close to the IP Federation. So, first of all, why do you think it is so important to see an improvement in social mobility within the IP professions?
Well, it won't come as a surprise that social mobility is close to my heart, because I mean, I don't like to talk about myself too much, but I'm an ex-council house kid from South Wales. A good portion of my upbringing was in a single parent family. I'm the product of a state education. And as you heard earlier, I only went to uni because IBM paid for it. I wouldn't change any of that though for the world. I mean, I've grown to recognize that privilege is genuinely not a useful indicator of the potential contribution that a young person can make in whatever it is they go on to do. And there are some incredibly bright young people out there who maybe don't enjoy the privilege of some others. And that's a real shame. And so I have a natural inclination towards helping in that area. But when you then go further and think about my profession, the patent attorney profession, which, as you know, I kind of fell into ultimately, it's got some stereotypes associated with it. So you stereotypically, the patent attorney is, you'll forgive me for using a stereotype, it's a white, middle-class male, predominantly, often with a higher degree, very often with degrees from a very small subset of universities, Oxford, Cambridge, the Russell Group universities. And so this is often seen as a stereotype and among the profession. But the reality is, and the really awesome organization that is IP Inclusive helps us see this, the reality is that is not a stereotype, it's actually reality. Okay, because according to IP Inclusive surveys, I think more than 90% of our profession is white. More than 80% are middle class, and by middle class, and these people were never eligible for free school meals, like many others were. Nearly 3/4 are male. And over half went to Russell Group universities. So, and Russell Group universities are hard to get into statistically for those from less privileged backgrounds. So I see this stereotype as being real. It's an actual type, and it's really unfortunate. And so, as much as I have this background that inclines me towards assisting with social mobility anyway, to then be in a profession where the sort of people from backgrounds like mine would struggle to achieve gives me even more impetus to get involved and to help. I think that the profession is somewhat dominated by privilege, and that's a real shame. Every bright young person not fitting that stereotype is a missed opportunity. And as I said to my colleagues at the IP Federation, it's simply not good enough. It's just simply not good enough. And we've resolved the IP. I mean, it didn't take much convincing. We have other members of the IP Federation who have very similar backgrounds to my own, immediately on board, and all other member representatives immediately saw the value of this initiative. So there was no need to discuss it. We resolved to challenge the state of affairs, I think, is in a nutshell.
Okay, so as a matter of practicality, what is IP Federation going to do to promote these causes?
Oh, absolutely. I mean, we don't just talk about it. So we, as I said a moment ago, we've worked with IP Inclusive, and IP Inclusive is phenomenal. Andrea Brewster has done some amazing work through that organization. And so we went to IP Inclusive to gain some guidance, I suppose, on how one can not just talk about inclusion, diversity, but also actually make a difference. And Andrea helped us, put us in touch with charities, helped us understand how events can helped us see what the problems are that need to be addressed. And the problems really for the patent attorney profession, to take the specific example, are knowing what stops people from less privileged backgrounds from coming into our profession. That's the problem in a nutshell. So earlier this year, even in the context of a lockdown early in 2020, we had a diversity and inclusion roundtable, which was attended by some really quite senior people from a whole range of organizations involved in intellectual property. We had Tim Moss from the Intellectual Property Office, the CEO. We had representatives from IPREG, the regulator, and many organizations that are keenly involved at a very senior level. And we broke out into breakout groups, and we resolved to come up with very tangible actions that we could take to make a real difference. And every breakout group came back with something that we could actually do. And then every breakout group committed to pursue at least one of those ideas. And they ranged from relatively straightforward things like raising knowledge and understanding. It's remarkable how fascinating the job of a patent attorney or a trademark attorney or any other, or an IP solicitor is. It's really interesting. I mean, when I talk to young people about being a patent attorney, and I effectively boil it down to working with inventors on cool ideas every day, that's pretty much what it is. And kids get that. That's kind of fun. Okay, there's a lot more to it than that, and we can come on to that in a moment. But for now, think about the inventors and think about the cool tech. So it's about that, widening access to understanding that. And then we acknowledge that the education is a bit southeastern focused in the UK. So by that I mean, if you wanted to do one of the postgraduate certificates in IP law, for example, you're genuinely looking at mainly universities in the southeast of the UK. And we just thought, well, why is that? Why can't we have? Because people with less money, frankly, can't travel. Okay, people with less money, they might need to attend a university close to home. And so it should be possible to do that. Or, and as we've seen recently, remote learning, it works, it's phenomenal. So we're exploring that with academic institutions and seeing whether we can improve that. Then there are really challenging issues that we wanted to make tangible change and effect on, like bias in recruitment. So we recognize, and this isn't conscious bias, I'm not talking about discrimination. I think every organization I've worked with in IP is fairly wholesome. Okay, the IP law firms, the industry departments, all the associations, they're not discriminating. But there are latent unconscious biases within us that can cause challenges when it comes to questions of recruitment. And it's really unfortunate because we're not even aware of them most of the time. And we've all got them and we need to address them, I think. So we recognize that that's another challenge. And, it's really challenging to address that, because how you can even spot these unconscious biases, because they're unconscious by their very nature. But then better than that, how you can address them and avoid them for example, in recruitment activities is something we're looking at very closely. And within the Federation, we're looking at unconscious bias training for our members as a start to rolling that out going forward. And then, at the other end of the spectrum, I suppose, would be really bold ideas like how you change getting into the profession in the first place. I mean, we take inspiration from the legal services professions and how there have been some really effective changes of late to how you might become a lawyer in the UK, maybe apprenticeships, maybe changing to the qualification routes. These are just discussions. I think just having the dialogue on these issues is useful.
Yeah, it's interesting you say that, because apprenticeship has certainly raised its head again, and it's only like turning the clock back 60 years, because when I first joined this firm, that was Ragn&Co, when I joined it, the firm I'm still at now, our senior partner had not graduated. He did a 6-year apprenticeship to become a lawyer, and that was perfectly normal. More years ago than I care to think about, I used to be in charge of our graduate recruitment, and one of the things I did at the time was to say, well, if you limit what you're doing to universities, then you've already missed the first step of this on this ladder, because, as you said yourself, not everybody gets to university, and the opportunities are limited. So we used to go into the schools and try and sort of sell the notion of the legal profession generally to school kids, and make it interesting and funky, and try and get them, keen on driving down that road. And of course, when you then narrow that down to IP, and as you said yourself, as an IP patent attorney, you're ahead of the cutting edge. I would have thought that's a great message to take to sort of 14, 15, 16-year-olds who might be thinking about the future a little bit by that stage, and would find it exciting.
Absolutely. And the IP Fed has really impressed me this year, because one of its you asked for tangible things we do. This year we committed to support an awesome charity that Andrea Brewster of IP Inclusive put us in contact with, called Into Science UK. So Into Science specifically targets young people from disadvantaged backgrounds to give them work placements in STEM, science, technology, engineering, maths, companies and organizations. And it's done this for hundreds of young people every year. We have partnered up with them, and we're helping them with that, both financially, but also practically. And we've just been so impressed with the work they do. Even through this lockdown, they've maintained their objective of getting hundreds of young people through that. And it opens the eyes of these people, because these young people, they genuinely, free school meals is a useful indicator of being from a disadvantaged background. Okay, so they genuinely have a very large proportion of the young people they work with are receiving free school meals, which is sort of an unfortunate way of tacking. But then more than 80% of them have come from families where there's no experience of higher education at all. And so that's, it's been really valuable to see that work, and to see it continue through the lockdown. But the point you made just then about university is interesting, because, and I take a very personal interest in this, because I'm an examiner for the European qualifying exam for the European patent attorneys. And the enrollment criteria for that exam include a requirement that a candidate has undertaken a full-time course for their undergraduate degree. And I have a real problem with that, because if you've come from a maybe less advantaged background, the chances of you having gone straight into uni from school are less than they would be if you're from a more privileged background. And you may come to your higher education at a much later stage in life, and that may mean you do it part-time. Now, if you're studying maths or physics or chemistry or engineering, you're no less a graduate of those subjects because you've studied part-time. And I've always had a problem with why the criteria for enrolment for the EQE require a full-time degree. So the point you make about getting them, getting access to these people as youngsters, but then coupling that with the reality that people from disadvantaged backgrounds have a different route. We really need to recognize this, and we're actively lobbying for changing that sort of stipulation in the requirements.
Now we're having a great conversation, and its time is ticking on. There are a couple of things I'd like to just run by you, but let's move on to the last few questions now, if I may.
Yeah.
I'm always one to try and get a bit of free consultancy when I can. So let me ask you this one. You look back across the fence from industry to the legal profession. You were in it once as a patent attorney in private practice. So whether it's solicitors or patent attorneys, what do you think the professions could do better to improve their service to the IP owning clients?
Right. Yeah. Well, I mean, everyone can always improve, but I think it would be remiss of me not to acknowledge that in the UK, we have one of the best legal professions in the world. I mean, it's world class, it's recognized as world class, it's effective, and we also have a reliable judiciary. So we're working in a very high quality environment. But that said, there's always opportunity to improve. But I do want to acknowledge that, because that's important. And I don't want to suggest that the legal services we receive in industry is anything other than on par, if not above. If there was one suggestion I would make, I suppose it would be in respect of commercial insight. I see a fundamental challenge between law practices and industry, which is that law practices are businesses as well. So law practices, of course, need to grow and succeed and to continue to provide their services. And in fact, industry depends on them succeeding, because without good, successful law practices, we do not have that rich, highly experienced, highly qualified set of expertise to draw upon. So it's in our interest that they do really well. And to do well in a law practice, of course, you generally, seniority comes with great experience, great client relationships, revenue generation in private practice. That's how people grow in private practice. Whereas in-house, I think seniority comes not so much because we have no client experience, we don't have followings, and we don't bill. So in-house, our experience comes from understanding strategy, understanding the commercial realities, applying them to getting good outcomes, only good outcomes from the advice we give and the relationships we have. And there's therefore a little bit of a disconnect, because law practices will often struggle to justify bringing into their fold the industry expertise that has got such rich insight into how industry and commerce and business works, because these people are maybe not as they're not as suited to the law practice environment. And yet that expertise is exactly what industry desperately needs. I mean, it's the only reason, I suppose, that we always maintain an in-house department, because we can then bring the extraordinary dedication and commitment and experience of the law practice to the commercial realities and the insights of the in-house lawyer. And the two together then give you the sort of the perfect coupling. But yeah, so I suppose that the one thing, I don't know how you solve this problem. I wonder if maybe an increasing emphasis on secondments, even closer working. But if we could get that, because we need our lawyers to have, they need to be skilled negotiators, which in many cases they are, but in new contexts, influencers, policy setters, and have that real insight into what we're worried about. I know that lawyers, they acknowledge that sterile advice is not useful. They know that. But I still see quite regularly requests for counsel and legal advice being met with relatively sterile advice. And by that, I mean advice that is actually completely factually correct on the basis of the position that's being presented, but kind of stops at the point where we really want it to start, which is that you've given me the legal analysis, and that's phenomenal. And I think we could have done that ourselves. But what we really want to know is, what actually can we do? And what is it beneficial for us to do? So, but I make that observation in the context of us having probably the world's best legal services sector. So please take it in that context.
I certainly do. And that is a message, I think, that has been conveyed to the legal profession many times down the years. As you said, secondments, I think, are valuable. Sector specialization is also valuable. There are ways we can address it, but it's something that needs to be kept in mind. Right, last question. What next for IP Federation, and what next for you?
Oh, the IP Federation, I mean, the challenges are daily. There are always new challenges, and I'm confident that we will keep abreast. I wouldn't say, we're not maintaining the status quo. We are always watching and always responding. So it's a bit like a machine that is running at very high RPM, and I'm confident that it's going to remain in that state of readiness. We're keen to grow our membership. Absolutely, every additional member we get in the IP Federation just enriches our expertise. The great thing about our membership is that every member has an equal say, so you have as much influence and insight whether you're a new member or an incumbent. And it allows us to enrich what we understand are the concerns of an even greater diversity of sectors and of businesses, actually, every new member gives us additional influence, because the bigger we are, the more say that we would be perceived, at least, to have. So I think from the IP Federation's point of view, growing our membership and continuing to address those challenges on an ongoing basis is naturally going to be core of our objectives. But for me personally, I'm a patent attorney. I'll always be a patent attorney. I will continue drafting. I will always be drafting. I'm never going to be one of those attorneys who suddenly stops drafting patent applications. I've committed to that. Prosecution hearings, that's my bread and butter. I'm really keen to play around with the AI issue and the intersect with IP. So you'll probably see me in that sphere coming up. And I think in that respect, I'm really keen to maybe affiliate with an academic institution, because it'll help me drive policy and also maybe inspire the next generation of IP attorneys. So that's maybe where I'm looking next, but certainly exciting times, absolutely.
Well, they are. And I love the fact that after so many years in the profession, your enthusiasm is completely undimmed.
Absolutely.
So thank you so much for being my guest today, and thank you for sharing your views and thoughts with me and with our audience.
Absolute pleasure.
I'll be back soon with another one of these conversations with leading lights in the IP world. But for now, thank you very much to everybody for watching or listening, and for your interest and attention. And thanks once again to Scott. Thank you.